Hello and welcome to the inaugural webinar in the Breastfeeding Works series. This webinar is brought to you by many organizations, all of which work together as part of the USBC affiliated workplace support constellation. Today's presentation is co-hosted by A Better Balance, the American Civil Liberties Union Women's Rights Project, the Center for Work-Life Law at the University of California, Hastings College of the Law, the U.S. Breastfeeding Committee, La Leche League USA, Reaching Our Sisters Everywhere, the International Childbirth Education Association, National WIC Association, and U.S. Lactation Consultants Association. My name is Cheryl Lebetovich, and I'm the Senior Workplace Program Manager and Policy Analyst for the USBC. And I'm going to start us out with some context on the experiences of breastfeeding employees in the United States before passing the baton to this incredible panel of legal experts who will help you understand the legal landscape surrounding breastfeeding employees and students and how you can support families as they transition back to work or school. Liz Morris, Deputy Director at the Center for Work-Life Law, will talk about the Fair Labor Standards Act Break Time for Nursing Mothers provision. Galen Sherwin, Senior Staff Attorney at the American Civil Liberties Union, will discuss protections for breastfeeding employees under Title VII of the Civil Rights Act. Sarah Braffman is a staff attorney from A Better Balance, and she'll share about the state laws that impact breastfeeding employees, as well as family and medical leave legislation. Jessica Lee, staff attorney from the Center for Work-Life Law, will tell us about the laws that protect breastfeeding students, as well as how to write an effective note for lactation accommodations. And finally, our panelists will walk through common scenarios and the steps you can take to provide support, as well as the top resources to consult when you or your patient need additional support beyond what you're able to provide. And we'll also have time at the end to answer your questions. A recording of this will also be available, and we'll provide the link where you'll be able to find the recording. So starting at the very beginning, we know that mothers are separated from their babies for many reasons. In the United States, 61% of children under the age of 5 are in some type of regular child care arrangement. For the majority of families, this is due to a caregiver returning to work or school. The fact is that employment is the norm for women of childbearing age. 62% of women return to work before their child's first birthday, with 23% returning within just 2 weeks of giving birth. And we know that some groups are disproportionately affected. For example, African American women return to work on average 2 weeks earlier than women from other racial and ethnic groups. A lesser known statistic, I think, is the fact that 26% of undergraduate students are parents of dependent children, and half of these students have children who are 5 years old or younger. These circumstances have a significant impact on the breastfeeding experience. No matter where they are or what they're doing, breastfeeding mothers must pump breast milk about as often as a baby usually eats. This is critical for her to maintain her milk supply, ensure that there is adequate milk for baby while she's away, and to avoid leaking, inflammation, and infection. And while facts and figures can help, it's real-life stories that can best illustrate what life is like for breastfeeding families. This first story comes from a Huffington Post report following a review of 105 cases as part of a Freedom of Information Act request for investigations into nursing mother complaints. Consider the travails of an employee who is instructed to use an employee bathroom, according to an investigator's report. This arrangement apparently necessitated sitting on the bathroom floor. The woman tried switching to a public restroom in the building, which was frequented by others while she expressed milk. The woman eventually switched back to using the employee restroom due to a sewage problem with the public one. This next story comes from an OB nurse and lactation consultant in Indiana named Sandra. Yesterday, I had a call from a working mother in pain because her plan for continuing to breastfeed when she returned to work was not going well. She works full-time and has 2 15-minute breaks during her 8-hour shift. She does not have any additional time, such as a lunch break. She worked Monday through Saturday. She simply did not have enough time to pump during work. And as you likely know, unfortunately, these challenges are not uncommon. We hear from families all the time about the challenges they face trying to combine breastfeeding and employment. And while it's true that returning to work or school shifts the breastfeeding journey, by no means does separation of a mother and her child equal breastfeeding cessation. Simple, inexpensive accommodations make a world of difference. Things like break time, a clean private space, and a safe place to store expressed milk might be all it takes to help a family combine breastfeeding and employment or school. And healthcare and lactation support providers and childbirth educators in particular are uniquely positioned to provide support to families when they need it most. In our audience today are hundreds of providers who touch thousands of families across the nation. And we have an incredible opportunity to connect each other to the information and the resources and the support that can help breastfeeding families before, during, and after they return to work and school. We know that you wear a lot of hats and you're asked to cover a lot of information and not a lot of time with the people you serve. So no one is expecting you to become fluent in lactation legislation. Rather, our goal today is to make sure that you have enough information to point families in the right direction, because you are so often the ones that families turn to. So by assuring them that there are legal protections on their side, as well as individuals and organizations who can provide the support that they need along the way, we can create a stronger web of support for breastfeeding families than ever before. Yet, research shows that 60% of employed women do not have access to both break time and a private space to pump during the workday. And that low-income women are more likely to return to work earlier and have jobs that make it challenging to continue breastfeeding. And since women of color are disproportionately represented in low-income, non-managerial positions, they are also facing the most barriers to breastfeeding success. So while the struggle is real, so are the solutions. Women with both adequate break time and private space to pump were 2.3 times as likely to be breastfeeding exclusively at 6 months. Just like stories helped us connect to the challenges that many families face, stories can also help identify the solutions to these challenges. So first, I'm going to share a story from a mom in Ohio. She wrote, "I gave birth to my first child in 2008. I was returning to work full time and knew I had no private place to pump. I stopped nursing at 8 weeks. In 2011, I gave birth to my second child. The same employer had converted an unused room into a nursing mother's room, a private room with access to an outlet and a small fridge. I was again returning to work full time, but with the law and my employer's accommodations, I was able to nurse my child for 7 months." This next one is from Kimberly in Missouri. She said, "I worked for a major corporation that provided new moms rooms for mothers who needed to pump. Knowing that room was available let me know that pumping would be supported and even encouraged. With all the stressors of work and home life, having this was a load lifted. I could concentrate better on my work. Also, it made me value my employer even more. I believe it raised morale among most of the pumping mothers as they knew they were not in it alone." And this next story is my favorite. It comes from a mom in Virginia named Carolyn. "I had my first child at 21. I didn't know anything about breastfeeding, but a woman I worked with shared her breastfeeding books with me, and I learned that breastfeeding was the healthiest choice for my child. When I went back to work at 11 weeks postpartum, I wanted to continue giving my milk to my child. This was in 1984. There were no double electric pumps then. I pumped 2 to 3 times a day for 15 minutes using a battery-operated single pump while sitting on the toilet in the women's bathroom. Fast forward to that same child 29 years later, when she had her own daughter 3 years ago. The scenario was much different. We had the Affordable Care Act. Her pump breaks were protected when she went back to work at 12 weeks. She was provided a clean private space with a sink so she could pump her milk without concern of contamination from pumping on a toilet. Nobody harassed her as they did me. She was provided a double electric breast pump from her insurance company because it was now recognized that providing breast milk would actually save in healthcare costs. I cried when I found out she was afforded these rights. And what a difference these stories and the other stories we heard. These wonderfully demonstrate how policy changes and the right support at the right time can make such a big difference for families. So that's why we're now going to turn our focus to how you can help support your patients and your clients to have positive outcomes after returning to work or school. We're going to start out by getting some background on the laws that may provide rights to accommodations and that prohibit discrimination. So with that, I will pass the baton to Liz Morris from the UC Hastings Center for Work-Life Law.
Thanks, Cheryl, for painting that vivid picture of where we're currently at. Hi, everyone. I'm Liz Morris from the Center for Work-Life Law. We thought that before we jump into the laws, we could take a moment for all of you to participate in a real-time poll to determine sort of how these issues impact you. So this will be the first of two polls during the webinar. So here you see it on your screen, and you can simply click the answer. Has a client ever come to you with questions about breastfeeding after returning to work or school? So go ahead and select the answer that applies to you, and we'll check out the results.
Okay, we're at about 70% total voting. We'll leave it open for about 10 more seconds.
All right, so we see that an overwhelming number of you have had questions about this come up. So you have come to the right place. We're going to tell you everything that you ever wanted to know about breastfeeding laws at work and school, and then we're going to talk through with you how to actually use that information in your practice so that you can effectively support your clients and your patients. So if we could, great. We're going to start off our discussion on the legal rights that your breastfeeding patients may have by talking about a law that you've probably all heard of, the Break Time for Nursing Mothers Law. This law was enacted as part of the Affordable Care Act in 2010. The Break Time for Nursing Mothers Law provides two important things that you should know about that your breastfeeding patients may need at work. First, it provides reasonable break time as needed by your patient to pump breast milk. So keep in mind that most workers in this country don't have control over when they take breaks, and they have to actually be granted permission by their managers to take time away from their duties. So this law requires managers to provide breaks at the times needed by the nursing employees, which of course you all know roughly follows the baby's normal feeding schedule. The break should be given as frequently as needed and should last as long as is reasonably necessary to get to the pumping location, to set up the pumping equipment, to pump the milk, to clean up and store the milk, and to return back to the work area. The breaks don't have to be paid under this law, but if an employee is using her normally provided paid breaks to pump breast milk, then it still has to be paid as it normally would be. Also, if your patient is still required to do any work for her job during the pumping break, then the break still has to be paid. So for example, if your patient's required to answer phones for her employer while she's pumping, then that isn't an unpaid break simply because she's pumping during that time. The second thing that the Break Time for Nursing Mothers Law provides is that it requires employers to provide private, non-bathroom space that's shielded from view and where coworkers and members of the public cannot intrude. So again, most workers in this country don't have private, space, don't have an office where they can shut the door. They have to be given permission to use a private space for pumping that's at their work site. And this law requires employers to provide that space. So what does it mean to be private and free from intrusion? Unfortunately, we don't have clear guidance on this, and what's considered private and free from intrusion is going to depend on what's going on at the particular work site. But generally, the employer is going to be required to take steps to make sure that no one's barging in on the employee. And you can put a sign up on the door or have a lock on the door, for example. Also, the space should, at the very minimum, have a seat and a surface to put the pump down on. Ideally, it would also have an outlet or an extension cord for plugging in a pump, and would be close to the work area and close to a sink and a refrigerator. There's no requirement that the space be a permanent lactation room, but it does have to be made available as the employee needs it. And I think it bears repeating that the space cannot be a bathroom because, of course, food should not be prepared in a toilet stall. These accommodations have to be provided throughout the first year of the baby's life. Okay, so as experts in breastfeeding, as I said, you've probably all at least heard about everything I've said so far. So what we want to do now is tell you about a few things that you may not have heard. The first is that there's a common misconception about the break time law. I think every other news article I read about this law says that it doesn't apply to employers with 50 or fewer employees, but that is not true. This law applies to employers of all sizes. Now, employers that have fewer than 50 employees may be exempt from complying in a particular case if complying would cause an undue hardship. An undue hardship is a significant difficulty or expense on the business. And whether there's an undue hardship is determined on a case-by-case basis, but we look at things like the employer's resources, the employee's job, the type of business, what the work site is like, those types of factors. There are actually no cases interpreting undue hardship in the lactation context, but based on what we know about the meaning of that legal concept from other contexts, and also the relative ease with which lactation accommodations can typically be provided, including in some difficult cases where we just have to use creative problem solving. I think it would be a really rare case where an employer would truly have an undue hardship. But most important thing to remember going forward is that this law actually applies to employers of all sizes. The next thing to be aware of is that there are a few limitations of the break time law that unfortunately mean we can't rely on it to give breastfeeding workers everything they need. Because the break time law doesn't give employees everything they need, it's important to know about other laws also that provide additional protections. And we're going to talk about those laws in a few minutes. Before I tell you about the break time law's limitations, I want to make clear that despite these limitations, the break time rule is an incredible law that undoubtedly changed the game for nursing women in the workplace, nursing parents in the workplace. It's a clear mandate to employers to provide break time and space, and it sends the message, as we heard about in some of the stories that Cheryl shared with us, it sends the message that accommodating nursing parents at work is the norm. But still, as I said, we also want to be aware of these limitations. Now, the first limitation is that because of the way the law was written, it doesn't cover everyone. In fact, it leaves out some very important groups of employees in industries where we see a lot of women of childbearing age working. The law provides rights only to employees who are, quote, non-exempt from the FLSA's overtime requirements. In other words, this law only protects workers who are entitled to overtime under federal law when they work more than 40 hours in a week. So that means it doesn't provide anything for many administrative, executive, and professional employees like teachers or true managers. It doesn't provide anything for airline and railway workers, agricultural workers, and a number of other categories of employees. So there are significant gaps in coverage under this law. Second, there's significant challenges with private enforcement of this law. So what do I mean by that? Typically, when an employer violates a workplace law, the employee can sue the employer for monetary compensation in court. The employee who has been harmed can hold the employer accountable for not following the law. And that's important because, money damages compensate the person who's been harmed. But it's also important because monetary damages deter unlawful behavior. If employers are worried that they're going to face a costly lawsuit if they don't comply with the law, then they're going to be more likely to comply with the law. The break time law simply doesn't have that kind of a bite to it. And so it's important to know that there are other laws that do have more teeth, which we'll discuss shortly. Now, I don't want you to walk away thinking the law has no impact on employers, because that's certainly not true, and that's not what I'm saying. Companies generally don't want to be in the position of violating the law, no matter what the consequences may be. Also, the Department of Labor's Wage and Hour Division accepts complaints about violations of the law and can intervene with the employer to attempt to get the nursing employee the time and space she needs, assuming it's not too late at that point. It's also really important for you to know that in the event that an employee complains that she isn't being given her time and space under this law, and then she's retaliated against in response to that complaint, so she's fired or demoted because she complained, then she could file a lawsuit for monetary compensation in court. Okay, the final limitation to know about is that the law provides only break time and space. Now, that is most of the battle in most cases, but still the law doesn't require employers to provide other accommodations that may be needed in some cases. So, for example, someone may need a temporary transfer to another position if their normal work somehow interferes with their ability to breastfeed or their ability to breastfeed safely. The law also doesn't, the break time for nursing mothers law also doesn't prohibit discriminatory treatment or harassment based on breastfeeding. So passage of the break time for nursing mothers law was huge, significant progress, and really a wonderful step toward changing workplace culture around this issue. But of course, we still have these shortcomings. So now we're going to hear from Galen and then Sarah about other laws that may be used to fill in the gaps left by these limitations.
All right. Hi, everyone. I'm Galen Sherwin. I'm with the ACLU, and thank you all for joining the presentation. This has really been a great collaborative effort from all the panelists and the sponsoring organizations. So I will jump right in, hopefully able to advance. Yes, there we go. Advance the slides. You've heard Liz just presented on the wonderful nursing mothers law really was a game changer, and she briefed you on some of the gaps in coverage and enforcement problems, and that's where the anti-discrimination laws that are going to be discussed in the next section of this presentation can play a really important role. The leading source of protection that I'm going to be focusing on today at the federal level is Title VII, which is the federal law that prohibits sex discrimination in employment. Title VII has much broader coverage than the work time law, the break time law. It applies to employers, all employers with 15 or more employees, and it provides a clear legal remedy, meaning a way to get to court, and a possibility for monetary compensation, as well as changes to employers' policies and practices. So employees can actually get what's called injunctive relief, which means an order that the company change its practices if it's not in compliance with the law. Title VII prohibits treating workers differently because of sex in a way that impacts the terms and conditions of their employment. Terms and conditions include things like whether you get hired or promoted in the first place, job benefits, work assignments, and of course, pay. But what does the term because of sex cover? And here a little history is worth getting into. The law is set out in Title VII, which was a statute that was enacted by Congress, but as with all laws, it's up to the courts to interpret any terms in the law that have any ambiguity. And unfortunately, the courts have sort of stepped in it in interpreting the meaning of Title VII and what it does cover. The first misstep was the Supreme Court's initial interpretation of Title VII's prohibition on sex discrimination as not covering pregnancy discrimination. And this came up in a challenge to an employer health policy that excluded coverage of pregnancy pregnancy-related medical care. And the Supreme Court in that case reasoned that this exclusion from coverage was not discrimination on the basis of sex because the category of workers who were not pregnant included both men and women. So in other words, because not all women are pregnant, discrimination based on pregnancy was not discrimination based on sex. Recognizing the flaws in this reasoning, Congress then stepped in to swiftly pass an amendment to Title VII, the Pregnancy Discrimination Act, which actually turns 40 this year. And the Pregnancy Discrimination Act defines the term sex as including pregnancy, childbirth, and related medical conditions. The law further specifies that workers who are affected by pregnancy and childbirth have to be treated the same as other workers who are similar in their ability or inability to work. So how does all this apply to breastfeeding and pumping? Well, again, in figuring this out, the courts once again kind of misstepped. The early cases on this point said that sex discrimination did not include breastfeeding or pumping, and the court sort of used the same reasoning that Congress had rejected when it enacted the Pregnancy Discrimination Act, which the image on this screen is an image of my blog post, which was entitled "Why My 4-Year-Old Understands Basic Biology Better Than Some Judges." The court started to course correct. The sort of an initial impetus was that the EEOC, which is the federal agency, the Equal Employment Opportunity Commission, which is the federal agency that enforces employment discrimination laws, including Title VII, said that discrimination based on lactation was covered. And it did so in a case called EEOC versus Houston Funding. In that case, the plaintiff, whose name was Domenica Venters, was preparing to return to work, and she disclosed that she was breastfeeding. She was on the phone with her supervisor, and her supervisor kind of paused and then said, "Actually, we won't be needing you anymore," and terminated her employment right there on the spot. And in that case, the Fifth Circuit Court of Appeals was the first appellate court to realize correctly that breastfeeding is like pregnancy. It's unique to women, and it's also a medical condition that is related to pregnancy and childbirth, and therefore covered under the terms of Title VII as amended by the Pregnancy Discrimination Act, and that therefore firing someone because they disclose their breastfeeding is, newsflash, a form of sex discrimination. So the court started to get it right in that case. The next case that really was a game changer was the Young versus United Parcel Service case that reached the Supreme Court in 2015. And in that case, Peggy Young, the plaintiff, was a package delivery person for UPS, and she needed a light duty assignment during her pregnancy because of a lifting restriction. And UPS gave light duty to other categories of workers who needed light duty for other reasons, but pregnancy was excluded because it didn't fall into any of those other categories. And in that case, the court held that in cases where the employer doesn't have a sufficient reason to treat pregnant workers differently than other categories of workers who are given particular benefits or accommodations, then that can be a form of sex discrimination that's prohibited under Title VII. The next case I'll mention, which was a really important development in the law, is the Hicks versus Tuscaloosa case. In that case, Stephanie Hicks was a police officer who had requested a desk job because the heavy bulletproof vest that she was required to wear when she walked patrol for her own safety would interfere with lactation. And there was evidence in the case that desk jobs were given to other workers routinely, but the police chief testified that he didn't think breastfeeding should qualify. And in that case, the court recognized that under Young versus United Parcel Service, employers have to treat requests for breastfeeding accommodations the same as other types of accommodation requests. So it was the first time the accommodation duty was applied in the context of a need for breastfeeding-related accommodations. And then the court went further and found that employers who fail to provide those accommodations can be held liable if the employee quits her job because her work situation has become objectively intolerable, which was true for Officer Hicks, who had to risk her life if she didn't wear the bulletproof vest, and that was just not a tolerable situation. So the takeaway here is that the courts have recognized that employers have a duty to accommodate breastfeeding workers to the same degree that they accommodate other workers unless there's a valid, strong reason not to do so. So I just want to mention that that was a huge development and really a game changer over the past, 5 to 10 years. Title VII also prohibits other types of discrimination that I just want to touch on. So we've talked about, the policy excluding insurance coverage for pregnancy. The same would be true constituting sex discrimination. The same would be true for a policy that includes coverage for breastfeeding. So explicitly treating breastfeeding differently than other conditions. Or if an employer had a policy that you could take breaks for anything except breast pumping, then that would be treating employees differently on the basis of breastfeeding, and that would be prohibited. Of course, the disclosure of breastfeeding leading to termination or demotion or a less good job assignment, that would also be a form of sex discrimination that's prohibited. Retaliation, which is when an employer punishes an employee for complaining about discrimination or asserting their rights under the law. And as Liz mentioned, that is covered under the break time for nursing mothers law. It is also prohibited under Title VII. So if you complain that you're being treated differently because of breastfeeding, and then your employer takes negative action against you, that would be prohibited retaliation. And finally, sexual harassment, offensive or sexual comments that are related to breastfeeding that create a hostile work environment for the worker. So if an employee is breastfeeding and being hassled on the job by her coworkers and her employer is failing to take steps to prevent it, that is prohibited also under Title VII. And there's one last one which isn't on this slide, but I will just mention, which is disparate impact. Title VII covers not just overt discrimination, but also discriminatory policies that, while they're neutral on their face, they don't mention pregnancy or breastfeeding, they have an adverse impact disproportionately on pregnant or breastfeeding workers. So examples of that would be, excluding breastfeeding from the ability to take breaks because you don't qualify for other reasons. Maybe it's not considered an on-the-job injury. Another example would be just failing to provide adequate facilities, even for an employer who isn't covered under the break time for nursing mothers provision. That would obviously impact all breastfeeding workers who needed access to private space to pump. So while this isn't the most well-developed area of law, it is covered under Title VII, and you should just be aware that even if something feels unfair because all pregnant workers or all breastfeeding workers would be affected in a particularly harmful way, then that may also be prohibited under Title VII. So that's a very quick rundown of federal anti-discrimination protections. And if we could pass the baton to Sarah Brafman now, staff attorney at ABB, she's going to talk about the really important additional layers of protection that are offered by state laws.
Thanks so much, Galen. So hi, everyone. I'm Sarah Brafman. I'm staff attorney at A Better Balance. We're a national legal advocacy organization where we work to promote fairness, equality, and justice in the workplace for women and families. And I am going to focus right now on state laws. So thank you so much to Cheryl, Liz, and Galen, and all of the sponsors. And I want to emphasize that everything I share, so there are 50 states, each state will have different laws, and it can be a bit confusing as to what the coverage might be in your state, but each of our organizations, the ACLU, Work-Life Law, and A Better Balance, we all have materials on what I'm going to share today. So what Liz and Galen spoke about were federal laws. Those are laws that apply in all 50 states. And state laws can vary. And what states often do is to add additional protections onto what federal laws apply to folks. So the first bucket of state laws that I'm going to focus on is general anti-discrimination laws. What Galen spoke about, Title VII and the Pregnancy Discrimination Act, many states also have anti-discrimination laws on the state level, and they'll be enforced by state agencies. And the reason why it's important when you're thinking about your breastfeeding clients and the discrimination that they may be facing is that state laws might add additional protections onto what federal law provides. So for instance, the Pregnancy Discrimination Act talks about pregnancy, childbirth, and related medical conditions. In the law itself, it doesn't talk about breastfeeding. Now, Galen spoke about court cases that have teased out that breastfeeding is part of that, but sometimes state laws will actually include in the law itself that breastfeeding is a related medical condition. So you don't need a court to interpret it. You just know from the outset that breastfeeding is included. So for instance, Utah defines pregnancy as pregnancy, childbirth, or related medical conditions, including breastfeeding or medical conditions related to breastfeeding. So if you were in Utah, you'd know, well, hands down, our state already has protections for breastfeeding. And many states also have additional layers of protection in their anti-discrimination law. And you might hear folks refer to anti-discrimination law as human rights law or as labor law. So when thinking about anti-discrimination law, it might be called something different depending on what state you're in. Now, the second bucket of state laws are what are called pregnant worker fairness laws. And what Galen spoke about with respect to accommodation, under federal law, employers need to provide accommodations if they're also providing accommodations to other sets of employees that aren't pregnant or aren't breastfeeding. And what pregnant worker fairness laws do is to say, you don't need to look at other groups of people and whether they're being accommodated. What this law says is that if you're pregnant or you are breastfeeding, then you need to provide accommodations to that employee no matter what. Just full stop, period, you need to provide accommodation. So what that means is if you have federal law, like Liz explained, where you get break time and space, that's super important. But let's say you need, a seat and more frequent breaks, or you need temporary duty because, breastfeeding is on the job that you have might be difficult, so you might need a different kind of position just for the time frame that you're breastfeeding or pumping. Then the law would provide that you need to provide that accommodation, and that's on top of break time, and that's on top of the space itself. And 23 states now have these pregnant worker fairness laws, and South Carolina is the most recent state to pass. So if you are in a state that has that law, it can often be a really great added protection on the federal law. The third bucket of state laws are time and space laws. And those are similar to the law that Liz described, the Fair Labor Standards Act, that provides for break time and space, but it's the state itself saying, we too have this law. And often states can have additional protections. So for instance, and I'm going to move to a slide that lists all of these states, but for instance, New York State has a break time law that says you need to be provided breaks and space until the child is 3 years old. So federal law says up to a year after childbirth, but New York State has this additional protection in its law that says you actually have to be afforded the space up to 3 years after the child is born. And the state law might also not have as many exemptions as federal law has, or they might have a lower employee threshold, so they don't necessarily have the undue hardship standard that Liz described. And the last category are laws that address certain groups. And so I'm actually going to turn to the next slide because you'll see what I mean by applying to certain groups. So all the states listed on this slide have a break time or a space or a law that applies to both. So a law that provides that employers need to provide both break time and space. And you'll see that in Louisiana, Montana, Texas, and Virginia, that law might not apply to all types of employees, but certain laws might apply to public employers only or to public schools only. So if you have a client that comes in who works in a public school or who works for the government, there might be protections for them that are important to remember. Now, the states in darker blue are the states that also include accommodations. So they are states that likely have pregnant worker fairness laws like I just described, and those accommodations might include things like I mentioned, like a temporary desk job that you might need if you're working on a job site that might not have easy access to a private space. And like I said, these state lactation accommodation laws, all of our organizations have materials on each of these laws. And one such resource is Work Life Law runs a website called Pregnant at Work, which has a wonderful map showing where different states have certain state level protections in addition to federal protections. So it's very user friendly. You click on the state and it basically lists all of the protections that that state might have. The USBC also has wonderful guides on their website as well that provide detail as well about what state protections apply. And a little bit later on, Liz is going to talk about a resource that A Better Balance and Work Life Law have put together that are user-friendly guides called Talking to Your Boss About Your Pump, about how to talk through going back to work, arranging for a space, the needs that you might have in a very realistic, user-friendly way, and also include the legal protections that exist on the state level. Now I want to move a little bit into a discussion about leave laws. So most of the presentation today is focused on what happens when you go back to work and what rights do you have when you go back to work. But something we know is that being able to take time off after you've given birth can lead to extended periods of breastfeeding. So the longer you're able to stay home with your newborn, the longer you'll continue breastfeeding. And so we wanted to focus a little bit just on what are the supports that are in place for being able to stay home. And unfortunately, in the US, those protections right now are fairly minimal on a federal level. So in the US, there is still no federal law that requires employers to provide paid time off to bond with a new child. And incredibly, the US is the only developed nation that does not have paid maternity leave. The only other country in the world, aside from the United States, that does not have paid maternity leave is Papua New Guinea. What we do have on the federal level is what's called the Family and Medical Leave Act. And the Family and Medical Leave Act provides for up to 12 weeks of unpaid time off to bond with a new child. And that includes biological, adopted, or foster children. It provides time to care for a family member with a serious health condition, and it provides time to address certain military family needs. Now, the FMLA, which is the first law that President Clinton signed into law in 1993, has certain eligibility requirements. And what those requirements result in is that almost 50% of workers in the United States are not even eligible for the Family and Medical Leave Act. So what are those eligibility requirements? Those requirements include that you need to work for an employer with 50 or more employees, 50. You need to have worked with that employer for 12 months, and you need to have worked 1,250 hours in a year. And what that really boils down to is about 25 hours a week. So the law does not apply to small employers. It doesn't apply to, for the most part, part-time workers, and you need to have worked there for a fairly long time. I should mention, because this is our state law section, that certain states have unpaid family and medical leave laws similar to the Family and Medical Leave Act. And those states might have requirements that are similar, but a little bit different. So some states might require that you only have worked there for 1,000 hours and not 1,250 hours. But for the most part, those state laws will mimic the Unpaid Family and Medical Leave Act law. Now, what does that look like when you're not able to take time to care or bond with a new child? Now, I think this is best illustrated through personal stories of what does it mean to not have time to bond with a new child and not be able to get paid for that time. Because even, and I should mention, even those people that are eligible for the Family and Medical Leave Act, if you're not being paid for that time, most workers can't afford to take unpaid time off, especially at this critical time when you have a new child to support. And I just want to share one story that is from a father actually in Massachusetts. His name is Jared. He's within the USBC network. And his experience was that what he said is, we experienced complications during my son's birth that resulted in oxygen deprivation and injury to our son's shoulder. His face was covered in bruises, making breastfeeding challenging. I had no access to paid parental leave and was forced financially to return to work just 3 days after my son's birth. When my wife needed me the most, I was not able to be there because someone had to be working. It was my job to care for them in those first weeks, but because I had to return to work so soon, I failed at that job. We knew how important it was to spend the first months together, but no matter how we added things up, staying home just wasn't an option. Now, Jared was in Massachusetts, and Massachusetts has actually become the most recent state to pass a paid family and medical leave law. And it joins 5 other states: California, Rhode Island, New Jersey, New York, Washington State, and Washington, D.C. So we now have 6 states and Washington, D.C. that have paid family and medical leave laws. And California, Rhode Island, New Jersey, and New York, those laws are already in effect. Washington, D.C., and Massachusetts, as you'll see, those laws are taking effect. The benefits of those laws will begin either in 2020 or 2021. And what those laws importantly provide is wage replacement for bonding with a new child, for caring for a seriously ill family member, for certain military family needs, and in certain cases for your own personal health needs if you yourself have a serious medical condition. So it's a hugely important growing movement of states that are passing paid family and medical leave laws. And we hope only a movement that continues to grow, because as we saw, if the Massachusetts law had already been in effect, that could have had a huge effect on Jared and his family and countless other families across the US. And finally, I just want to point to some resources. So A Better Balance runs a website called Babygate, and it's a 50-state guide that really covers all the laws related to pregnancy and parenting and includes the types of laws that I covered today. So the general anti-discrimination laws, the pregnant worker fairness laws, the state-specific break time and space laws, and the leave laws that I discussed as well. And the one resource that I want to point to as well, finally, is that we also have a chart that we hopefully keep constantly updating, because we're able to pass more of these laws on paid family leave laws. And that chart really breaks down what paid leave looks like in your state. And we also run a free hotline specifically on paid family leave should you have questions about that. And now I'm going to turn it over to my colleague Jessica to talk about schools and breastfeeding in the school context.
Thank you so much, Sarah. This is Jessica Lee at the Center for Work-Life Law, where I run the Pregnant Scholar Initiative and serve as an advocate for student parents and provide technical support to their institutions. Today, I'll be talking about protections for students who often struggle to find time between classes to pump, and face major challenges getting the private space to do so. Unlike in the workplace, there are very few states or localities where students have been provided with a clear right to time and space for pumping breast milk. California and Illinois, for example, have great laws, but the vast majority do not even approach students. So instead, we rely on the federal anti-discrimination law, Title IX, to set a baseline of protection for breastfeeding students. And here it is. Discrimination because of lactation equals sex discrimination. It's the same concept you just heard Galen from the ACLU discuss applied to this student setting. The interpretation of the law is new and guidance is lacking, but there are a few very simple bottom lines. The first is that schools must treat lactating students like other students with health conditions. And if a student's ability to get an education is limited because there's no reasonable time or place to pump, that is likely a violation of Title IX. Title IX is a federal law that prohibits sex discrimination in federally funded education programs. And I should note, based on some of the questions we've already received, that this applies to any education program that receives federal funding, and most do. So that covers nearly all public schools, private and public universities and colleges, and also other programs like school-sponsored internships or extracurricular activities. Programs in the community like library programs, vocational training, or prison education initiatives are all also covered under Title IX. Under Title IX and disability protections, students have access to time for expressing milk. Now, this time is typically in the form of what we call medically necessary absences or tardiness. That's because of the way the law is written. It excuses medically necessary absences relating to pregnancy and childbirth. So medically necessary absences or tardiness should be excused, and that should be excused without penalty. So that's without deductions for missing class, for example. But in order to access this, because of the way many schools run their accommodation policies, students will often need to provide a doctor's note explaining that they need this accommodation, if that's required of other students with similar needs. Students should also be provided a private and sanitary location, and schools must protect students from harassment. This is a especially important provision that we see coming up in the education context, is especially for the younger students. This can be essentially putting a target on a student's back for sex-based harassment. We've heard of this concept of folks mooing outside the door while a student or an employee at a school is pumping, and that's just not acceptable. Schools need to prevent that. And I should also note that the Department of Education encourages, although doesn't require, unfortunately, that schools provide a room with an electric outlet and refrigerator to students who are pumping. I should also note, under the time for expressing milk, I mentioned that medically necessary absences should be excused. Because we just had this discussion about paid leave in the employment context, I should also note that there are also provisions that say you get that time off for medically necessary absences related to pregnancy or childbirth. So there is a very short but important leave period for students as well. Now, again, all of this is relatively new. There aren't very clear, specific break time and space laws for most students. So I do want to highlight this resource here for any of you that work with breastfeeding students or pregnant students in general. We have a model breastfeeding policy, frequently asked questions, and a helpline. There are a ton of resources there to support you. Next, let's talk about best practices for care providers. First, let's talk about pumping early. Don't be afraid to include a discussion of pumping at work in your initial conversations about breastfeeding. This will help surface and address any of your patient's concerns early and give her a chance to talk with her employer or educator about accommodations before they become a crisis. you can help avoid the situation that we hear about all too often, where an employee is desperate, engorged, leaking, and scrambling in her workplace to manage accommodations on her first day back. You do not want that crisis. So encourage planning before the baby is born and remind her that those legal protections exist so that this return to work isn't seen in her mind as a tremendous hurdle to breastfeeding. Next, we want to spot issues with the employee who is back to work as early as possible. So many breastfeeding patients will not directly ask you about a breastfeeding law that protects them at work or school, but they may provide other clues that they are struggling with it. For example, your patient may mention that she has a reduced supply, or ask you about recurrent mastitis or plugged ducts or problems with engorgement. These are red flags that your patient may be having a difficult time arranging accommodations at school or at work. Next, we all know you aren't all lawyers, and it isn't necessary for you to solve those legal problems. But knowing when and whom to ask for help can make the difference for a patient who's faced with a situation where it seems her only option is to stop breastfeeding to keep her employment. Hopefully, we have identified resources throughout this presentation that can help you. Finally, this is the big one. Healthcare providers can write an effective note to help patients get accommodations at work or school. These notes are especially important for students who usually aren't protected by detailed break time and space laws, and for workers who aren't covered by the federal or state laws that provide clear break time and space, as we discussed earlier. Having a medical note can help make for a better comparison under anti-discrimination law, and it may help employees navigate workplaces with more challenging accommodation policies. Is the poll coming up? Maybe we missed it.
We can launch the next poll about writing a work school accommodation note.
Thanks. Yeah, I would love to know how many of you have ever written one of these workplace or school accommodation notes for one of your clients to help them get either break time, space, or other accommodations that they may need.
And we're at about 70% participation, so I'll leave the poll open for just maybe 5 or 10 more seconds.
All right, let's see how it stacks up. Never. Okay. Well, it seems from this that the majority of you have not written one of these notes before. So let's walk you through what this would look like. Writing effective notes for lactation accommodations. The first step for this is to educate the employer or the educator about breastfeeding and pumping. Even for those mothers who are protected by the more detailed break time and space laws, having a note from a healthcare provider can give them more credibility and more confidence in their discussion to seek accommodations, and it can serve a tremendous purpose of educating the employer. Unfortunately, many employers simply have no experience with breastfeeding. They don't understand that this is an important need for the mother's health. They don't understand that this must be done regularly. Some employers think you can just hold it, or why not skip pumping today? They don't understand the impact of any of this. So having that initial section in your note that educates the employer about breastfeeding and pumping, to explain that it's important and recommended, and to make clear that it's for the patient's health, is going to be a tremendous impact. We want to also be very clear that pumping accommodations are medically necessary for the patient's health for as long as she is breastfeeding. This is going to help make the case to the employer that they will benefit from having a healthy employee, and it also helps serve to check important boxes in case an employee does need to bring a complaint. She'll be better off if you make it clear that the accommodation is necessary for her health. Next, we want to be specific about the patient's needs. For example, the need for a private space other than a bathroom, the frequency and duration of breaks. Obviously, we're not going to be able to set the frequency and duration of her breaks throughout her breastfeeding life cycle, but we should note it's as needed. But for example, say at least X minutes of break time every, say, 2 to 3 or 2 to 4 hours. Next, you want to note any unique accommodations if they are needed, for example, uniform modification. And you want to be sure to mention if the patient or her baby does have a medical condition or impairment related to these needs. Finally, a good note will communicate that the accommodation is temporary and that the patient is able to continue working or studying. We don't want to set up a situation where the employer thinks the employee should be let go if they don't know how to put in place a great accommodation, or that the employee is just too fragile to work because she's breastfeeding. You would be surprised the stories we hear about some of these poorly informed employers. So your note can go a long way if you meet these steps. Finally, double check on your note that you answer these questions. Why provide these accommodations? When should they be provided? Where? And for how long? Now, all of this may seem like a lot, but thankfully we have a model note available on our website. We also provide some more detailed guidance about why we include what we do in that model note. But this can give you a guide of a very quick and succinct way to meet all of these goals and to help your patient meet her breastfeeding goals at work or at school with a very simple note. Next, we're going to talk about a few scenarios that you may encounter. Thanks, Jess. Hi, this is Liz Morris again. We are going to go through some hypothetical situations. We just provided you with a lot of information, and so we're going to see how this all plays out in the real world. So here's the first hypothetical. Sharon, a teacher, is returning to work in a couple months. Before going out on leave, she told the school's principal that she would need accommodations for breastfeeding when she returns. The principal said she didn't know if it would work out because there would be no one to cover Sharon's classroom and there are no private spaces available on campus. The principal told Sharon that they would discuss it when she returned to work. How do you respond? First of all, it's a good thing that you've solicited enough information from Sharon well before she returns to work, and you should encourage Sharon to get busy trying to resolve this as soon as possible. We want to avoid situations where someone shows up on their first day back, isn't accommodated, and then they may be sent home or risk their milk supply if they're not accommodated. Also, to the extent that something does need to be worked out, like here in Sharon's case, this bringing it up early will give people time, and really the more time that they have with discussing this with the employer, the better. It's also good that you've solicited enough information to understand the employer's position, so you can perhaps make practical suggestions to Sharon that would help her to satisfy her employer. So for example, here you may want to suggest to Sharon that perhaps another teacher could cover the classroom while she's pumping. Floater employees are good solutions for teachers and other industries as well, like for restaurant workers or retail workers. With regard to the space, you might encourage Sharon to explore with the principal whether there are spaces at the school that could be temporarily converted into pumping areas, like maybe a supply closet, or maybe they could purchase a temporary partition to actually put in Sharon's classroom so that she could pump there in privacy, even if somebody came into the larger room or was in the larger room. You may also be aware, this is new, there are these hand-free pumps that are battery operated and can actually be placed inside the bra, and then they can be worn while the person is working. So these are actually expensive, not surprisingly, and they don't, work for everybody's bodies, but an employer who doesn't want to rearrange work schedules to accommodate break time may actually be convinced to purchase one of these for the employee instead. And we've actually spoken to one employee who was able to make this work, and she continued doing her job, which involves physical activity like bending and lifting and pushing a cart. And she was able to continue to do that. And interacting with clients. She was able to continue doing that as normal while she was pumping with this hands-free device. Okay, so from a legal perspective with this hypothetical, as we discussed earlier, the break time for nursing mothers law does not apply to teachers. And so that's obviously not something you'd want to bring up with the employer, but if the employer did raise that point to Sharon, you could tell her that she may have other legal protections. And of course, as Sarah explained to us, it's a good idea to sort of educate yourself on whether the state where you work has any additional laws that apply by checking out the resources that we've provided. Also, because this is a school, Title IX applies. It applies to teachers too. So as you can tell, how the law is applied in each case can be complicated, and as we've said a number of times, there's certainly no expectations that you're an expert on the law, but it is important to encourage Sharon and all of your patients who have pushback from their employers to contact a free legal resource like the Center for Work-Life Law's free legal hotline, or simply contact any presenter on this webinar for help. In addition to legal support, you may want to identify for Sharon other key contacts who may be helpful to her, like has she spoken with HR? Because this is a school, perhaps she could talk to the Title IX coordinator. Employees, regardless of whether they're experiencing pushback from their employer, should always try to speak with their coworkers who have perhaps been able to make it work in the past. Additionally, in this case, note that Sharon is a teacher, which means that there's a likelihood that she's in a labor union. And I would encourage her to talk to the union rep who may be able to help. We received a question in advance of the webinar about what role labor unions can play in helping breastfeeding workers. And unions are all different, and some may be more interested in advancing protections for breastfeeding workers than others. That said, if they are on board, unions can serve as incredible advocates for pregnant and breastfeeding workers. Union reps understand the ins and outs of a workplace, and they can have access to information and to people that a worker on her own doesn't have access to. So they can help an employee to sort of negotiate with the employer to get what they need at accommodation-wise. Also, in the case where the employer isn't budging and isn't accommodating, they can file a grievance. The union can file a grievance to contest the employer's decision not to accommodate. So anyone who wants more information on how to work with unions on these issues should contact the Center for Work-Life Law. We've done work with unions and actually have relevant resources available for that. Finally, I'll note that after talking all these things through with your patients, you can offer to write a medical note explaining her need for accommodation and the health implications for both the baby and mom if accommodations aren't provided, as Jessica just outlined for you all. And can we go to the next slide? We saw from you all in the poll that most of you don't have experience writing the work notes, and so remember the resources that exist to support you. The Center for Work-Life Law and the ACLU Women's Rights Project created guidance for you as a care provider that summarizes what we discussed today and includes that model note that you can just crib from, as Jessica explained, and that's at the link provided on your screen for care providers. We're also really excited to announce a brand new state-specific resource for breastfeeding employees that we launched just yesterday. the Center for Work-Life Law and a Better Balance created these resources, and we hope they'll be of value to your patients. The resource is called Talking to Your Boss About Your Pump, and it provides practical tips and solutions for breastfeeding employees. So it includes guidance on how to ask for an accommodation and also information about legal rights. And so we have downloadable sheets available for each of the 50 states and DC because, the laws do vary from state to state, as you heard. So we invite all of you to print the resource and make it available to your patients, really as a matter of course when you counsel them about breastfeeding. Everything that they need to know is there, about workplace issues, is there in that one document. So talking to your boss about your pump is available at either of the websites that you see on your screen, Work Life Law's Pregnant at Work site or a Better Balances site. And we've also included a national version of the document in your materials today, but we really do encourage you to just go online and get the version that discusses the laws in the state where you actually practice so that you can print it out and have it available for your patients. So with that, let's move on to the next hypothetical.
All right, this is Galen Sherwin again, and I'm going to present this one. So you're working with Allie, one of your patients, and Allie works in a factory. And after she requested a private place to express breast milk, her employer directed her to use an old locker room. The locker room is disgusting. It's filthy and hot. There are bugs on the floor. There's no chair, so she has to sit on the floor. And she is, feels she has no choice but to use it, but on one occasion, she's using it. Someone leaves a milk pail outside the door while she's pumping. Her coworkers are frequently pounding on the door while she's using the room, and on another occasion, she finds that the lock has actually been glued shut with crazy glue, so she can't open the door. How do you respond in this case? Well, in this case, there's a lot of issues going on. Luckily, you know where she works, and it's in a factory, so you can tell that most likely she would be covered by the break time law. Most factory workers would be covered by the break time for nursing mothers law. The factory is also, if it's a big enough factory, it's probably got 15 or more employers, so it's probably also covered by Title VII as well as potentially the state laws that you've heard about. So you can tell just by knowing what you know already that there are probably a lot of legal protections that do apply in this situation. So, knowing that, having been told that she has to pump in a disgusting, uncleanly space with no chair, it's very likely that that space does not comply with the requirements of the break time law. And so Allie would, at a minimum, be able to go to her employer and negotiate about finding a better, more appropriate and sanitary location. In addition, the issues that she's experiencing while she's pumping, where people are leaving milk pails outside the door, where they're pounding on the door, and certainly the crazy gluing of the lock could constitute sexual harassment. She's being harassed because she's pumping, and the nature of the harassment, particularly with the milk pail, suggests that it really is because of the fact that she is lactating, is breastfeeding. So that type of harassment is also prohibited sex discrimination under Title VII. So you've got here at least a violation of the nursing mothers, break time for nursing mothers provision. You have potentially a sex harassment complaint here going on. And in that case, Allie has a couple of different avenues. She could, as Liz mentioned early in the presentation, if her employer does not fix the problems with the facility she's been given, then she can file a complaint with the Department of Labor regarding failure to comply with the break time for nursing mothers provision. With respect to the sexual harassment, She also, has a chance to let her employer know that she's being harassed. Most employers do have a system in place, and they should, if they're in compliance with the law, have a system in place for making complaints about harassment. Now, sometimes those complaints fall on deaf ears, but unfortunately, unless the person doing the harassment is actually her supervisor who has the authority to fire her or change her job conditions significantly, then the employer can't be held responsible for the harassment unless she notifies the employer about the harassment. So if she wants something done about it and the employer is not if she wants something done about the harassment, then she actually needs to go through the systems that are in place for reporting sexual harassment that apply within her employer. So advising her to at least gain familiarity with her own employer policies regarding reporting of harassment, so that the employer has an opportunity to correct the problem. And if the employer still does not take sufficient action that would prevent further incidents of harassment occurring, then she may well have a legal claim for a violation of Title VII. So all of this is to say, again, you're not required or expected to know all this off the top of your heads, but you have at least enough knowledge to identify that there are potential legal violations here. And if it looks like the employer really is digging in its heels and they are not responding, then you may wish to refer her to an attorney to talk over the situation. With that, I will turn it over to the next slide.
Thanks, Galen. This is Sarah again from A Better Balance. And our third scenario is Monica. Monica is a bus driver and works day-long shifts away from the bus depot. She tells you that there is no space for her to pump in private, so she will no longer breastfeed. How do you respond? So I think we can sum up the answer to this problem in 2 words, and that's be creative. So it's totally understandable that Monica thinks this is just going to be too difficult. I don't work in a traditional office space, so there's not going to be 4 walls and a lock on a door. There's no way that I could continue breastfeeding. But the reality is that there are so many breastfeeding parents who work outside of an office context, and there are so many different ways that this cookie can crumble. And so, for instance, for Monica as a bus driver, there are mobile lactation spaces, or there are, and I'll show you on the next slide, you see here, so this, it looks like a porta potty on the left, but it actually is a brand, it's not refurbished porta potty. It was something that looks like that, but was designed specifically to be a lactation space. On the right is what's called a mobile tent, and you'll see that that is actually in an agricultural context. So for farm workers, these kinds of spaces can also be hugely beneficial. Specifically in Monica's case, one interesting way to think about a lactation space, and in Los Angeles they do this for municipal employees, is that any bus driver in Los Angeles can stop at a firehouse along their route and use that firehouse as a lactation space. And so if there's not a specific law like that or requirement like that, then you can talk with someone like Monica and say, well, maybe the company that you work for can talk to businesses along the route that you work with, and maybe those businesses would be open along the way to allowing you to stop in and use that as a lactation space. Just some other interesting examples for farm workers. We've seen that using the cab of farm equipment, if you put up a visor, then you can use that. The same goes for a bus. If the company were to provide a protective visor for the bus, then you can stop the bus and use the bus itself as the lactation space. Again, there's the portable lactation spaces. We've heard of instances where if you work on a boat, the person can use the captain's office. In a construction space, you can build temporary spaces or use temporary partitions. So in any context, really, Monica's example is really just thinking outside of the office. And if there are women that come to you and need space outside of an office, there are so many ways to be creative. And what I would say is that there are great resources where you can find creative spaces as well. So HHS, the federal government, has a site that they run called Supporting Nursing Moms at Work, Employer Solutions, and they actually list different industries and the different spaces that might work for that industry. So fret not, there are so many different ways to create these kinds of spaces. And the last thing I'll say is that there are really 3 things to talk through with a client or a patient when they come to you with this predicament. So first and foremost is understand the employees and employers' needs. Understand, is it really the space that's an issue? Is it the time that's an issue? Or is it an accommodation that they need, right? In some cases, if Monica would be able to do a desk job for, a month or 2 when she needs to pump, maybe that would be better than these sort of mobile spaces. And if you live in a state where there's an accommodation law, then that might be a very wonderful alternative. The second is to determine what laws apply. So does the federal break time law apply? Does a state law apply? Does a public employee law apply? Does a pregnant workers fairness law apply? And again, you don't need to be to think of yourself as an attorney. We are all here to help answer those questions as well. So it's just important to remember, there might be between 1 and 5 or more laws that might be at play here. Let me try to think through the different laws that might apply to this patient. And then the last point is to identify key points of contact. So is there an HR representative that your patient should be talking to maybe a few weeks in advance to try to sort this out? Is there a union rep that they can speak with that can help them facilitate it? Or is there another local breastfeeding group that has seen many scenarios where they can help and step in and work with the employer as well to come up with creative solutions? So the response to Monica is, there are so many ways that we can help you figure out if you want to keep breastfeeding, that you will be able to do that. We just have to get a little bit creative. And now I'm going to turn it over to Jessica to discuss our last scenario.
Thank you. Scenario 4, Renee has back-to-back classes at her college with only a short break in between. She must leave a 3-hour lecture class a few minutes early to pump. Her professor docked Renee's participation credits and her course grade is suffering. The professor told her that that was her absence policy and there was nothing that could be done. How do you respond? Next. So this photo is actually of a high school lactation room. And we're very fortunate that there is a law here that requires it, but we know every school isn't supporting their student parents this way. So in your response to the student, you may want to let her know that her rights are protected under Title IX and that lactation discrimination is sex discrimination. The student should be able to pump without having her education suffer, and that means her absence should be excused. The professor's attendance policy, I've unfortunately had to say this way too many times, the attendance policy does not trump federal law, and it does not trump the accommodation policies of the broader institution. The student should ask for help on her campus, for example, from the Title IX office or the ADA office. She may also find support from a university breastfeeding support program, student parent program, or student group. Any healthcare providers that are listening, you could help this patient by writing the student an accommodation note stating that it's medically necessary for her to have access to time and space for pumping on a regular basis. This can help her get the accommodations she needs to stay in school and to stay breastfeeding. I really can't stress enough how important these notes can be for leveling the playing field in situations like this where there is such a power differential as a student and professor or teacher. This is especially important for students, but it's also important for employees, especially employees who are hourly, low-income workers, women of color, and other workers who are more vulnerable to discrimination and abuse at work. With an effective note, this mother isn't walking into an intimidating or potentially career-ending conversation alone. You are with her, and in most cases, her employer will know that the law is with her too. So next slide. That is the end of presentations. I know we're running out of time, but I think we can stay on for some questions. But to close out, I just want to reiterate, we are here to support you and your patients. There's a wide constellation of workplace support providers nationwide and in the community that can help breastfeeding workers or students facing challenges to strategize options for time or space, come up with creative solutions. We can help them negotiate, can help them file a complaint with enforcement agencies or in court, or my favorite part is to be proactive and put in place model policies to prevent this from happening in the first place. But I should say, in response to some of the questions that we received earlier, there may be some instances, which hopefully are rare, where you realize you've hit a dead end. It may just not be economically or personally feasible for the mother to keep pumping at work as often as she needs. At that point, your goal as a healthcare provider may shift to help the mother combination feed. I hope you'll keep encouraging her and remember that every bottle of breast milk or feed at the breast is a small victory that should still be celebrated. In the meanwhile, we'll keep fighting for a society where every worker and student is supported in meeting her breastfeeding goals, and we hope to provide you and your patients with tools and multiple layers of support to help them reach those goals. Please do not hesitate to reach out. We're here to help. For those of you who have to go, I guess we will say goodbye, but for others who will stay on, let's answer a few questions.
Thank you so much. That was beautiful, Jess. We do have a lot of questions, and again, if you have to go, this will be recorded. You'll get it right in your inbox, so you'll be able to see the answers to your questions later on. So our first one is, how do these federal laws apply to right-to-work states? And I'm wondering if either Liz or Galen, are you available to respond?
Yeah, sure. Hi, this
Sure.
is Galen. Oh, do you want to take it, Liz?
No, that's fine. Go ahead.
Okay, I was just going to say that, you know, the so-called right-to-work laws, which are laws that ostensibly prevent unions from forcing people to join and pay dues, those laws do not in any way trump the types of protections that we've been talking about here. So if an employee is covered under the break time for nursing mothers provision, then the existence of a state right-to-work law would not affect that coverage, nor would it affect coverage and protection under Title VII or other state anti-discrimination protections or affirmative obligations to provide break time in a private location to pump that might exist at the state law level. So basically everything that we have said today would apply in any state where a so-called right-to-work law operates. Liz, did you want to add anything to that?
Nope, that's it. Thank you.
Great. Our next question is asking the panel if in our lifetime we will see a federal law supporting paid maternity leave. And Sarah, were you available to take that one?
Yeah, I want to say a hearty yes. I think there is support for a paid family and medical leave law. There's a bill in Congress now that would provide for paid family and medical leave. And I say paid family and medical leave because we really see these laws as working for working families. So they all, a really comprehensive law would include paid parental leave, which would apply both to a biological parent as well as a partner if the parent has a partner, to adopted parents, foster parents, as well as cover caregiving needs that you may have and military family needs. And I do feel very hopeful that we will be able to move this, not just in our lifetime, but in the next few years.
Beautiful.
And if you're interested, I would just say also, if you're interested in getting involved, please let us know, as we continue to work on advocacy efforts both on the state level and on the federal level. So anyone that is interested in learning more about those efforts, please feel free to reach out to me.
Wonderful. We have a couple of questions asking about protections available for a dyad that needs to breastfeed directly. So this would be not a pumping break, but actually time to breastfeed directly. Jess, are you available to take that one? I know it's a little tricky.
Hi, sure. So unfortunately, the laws are a little bit more complicated on this section. As we mentioned, there are these very clear break time and space laws, which provide a clear path for employees and their employers. Obviously, that's less the case when it's direct breastfeeding, but there are a couple of things in our favor. One, again, those anti-discrimination laws and state level laws may come into play to protect the worker. Reasonable accommodation laws, if there is a medical need for this, this may be an accommodation. We should also note that employees are permitted, if they're permitted to have their baby at work, they should be permitted to breastfeed their baby at work. I actually saw this in the student context fairly recently, where a baby was allowed in the classroom, but the second she tried to breastfeed the baby, they were kicked out. That is sex discrimination. So I would just encourage anyone who's facing this situation where it is a little bit more gray to know that there are still many options, but I would recommend that they give one of us a call so that we could talk over the specifics of the situation, because it does vary so much based off of the medical needs at play and where this worker is.
Thank you. We have a question asking if teachers are also covered under Title IX.
Yes, teachers are definitely covered under Title IX. In addition to the employment protections like those anti-discrimination laws that we mentioned earlier, Title IX does protect teachers. And so like a regular worker would get in touch with human resources or union contacts, a teacher can have the additional option of getting in touch with their Title IX coordinator, which every school is required to have one. So you could file a complaint to your Title IX office on campus or just seek their assistance in negotiating accommodation.
Wonderful. We have a question asking which federal agency is responsible for enforcement of Title VII of the Civil Rights Act?
I can take that one. So the Equal Employment Opportunity Commission is the federal agency that enforces the anti-discrimination law. So that's both Title VII, the Americans with Disabilities Act as well, they enforce, the Pregnancy Discrimination Act they enforce, as well as states often have state level agencies that enforce anti-discrimination law. The one thing I would flag is that to bring discrimination claims, there's often what are called statutes of limitation. So you usually have to bring the complaint within either 300 days of the discrimination taking place, or in some states it can actually be 180 days. So you'll just want to be sure that if someone does come to you and they are interested in filing a complaint, that they are aware that they don't necessarily have tons of time within which they can bring a charge to an agency. But again, it's the Equal Employment Opportunity Commission, and sometimes you'll hear them referred to as the EEOC, and there are district offices around the country.
You can also contact the Department of Labor's Wage and Hour Division if we are looking at one of those workers who is covered by the overtime law. They will deal with enforcement of the break time for nursing mothers provision of the Affordable Care Act.
Thank you. Trying to look through our questions. We're looking for a link to Pregnant at Work. We'll include that on the screen, pregnantatwork.org. We have a question here about accommodations for military employees. I don't know that I have the answer to that. How about you, Liz or Jess or Sarah? We may have to get back to you all about that.
Yeah, there are so many different types of positions for military employees, but I think I was just reading an article the other day that was sort of telling a story about how some person who, was in active duty in the military out in the field actually received accommodation. So I think, as we said, to keep in mind, as Sarah said, to keep in mind, be creative. And so I think if there's a situation where there's particular circumstances that you're wondering about, if you contact us, we may be able to think it through with you.
Perfect. And there is an organization called Mom to Mom Global that is specifically provides support to military families who are trying to combine breastfeeding with the military life. So they are another really great resource. Their sister organization, Breastfeeding in Combat Boots, is another great one. Our final question is asking about notes from non-primary healthcare providers and whether these are as helpful as from the primary healthcare provider.
I always tell people that in the eyes of the employer, there may be some additional legitimacy from a note coming from a primary healthcare provider. So I do encourage people, if they can get notes from their doctor or their midwife, that can be more influential with the employer. But there's no legal requirement that the note come from, a doctor or a midwife. So even though lactation consultants are often actually more expert in what breastfeeding parents need, in the eyes of the employer, a note from a doctor or midwife may be more persuasive, but again, there's no legal reason why it should have to come from them.
Wonderful.
For the student context, it's often required that it come from a physician. But again, I would say there's absolutely no harm in providing that note, even if you aren't a physician, and many campuses will take notes from other healthcare providers.
Wonderful. If you have any remaining questions, please reach out to us. Any of us on the this webinar are available to you. Always happy to answer questions. You can see our contact information listed here. We also work together all of the time. So if one of us can't answer, we can connect you to the resources that you need. And appreciate those of you who are able to hang around for a little bit of extra time, and stay tuned for an evaluation and a recording of the webinar to hit your inbox soon. Thank you, everybody.
Thank you.
Thanks all.